My view about NDAs, where they are at the beginning of employment or ahead of an event, should be unlawful. You should not be prevented from disclosing sexual harassment in those sorts of documents. The law, I think, is very clear. Such provisions are void, whether it's in a settlement agreement or an NDA, if they prevent you going to the police or making a public interest disclosure. So bearing that in mind, I think the key question is, should the NDAs or the compromise agreements, settlement agreements, make it clear in bold type that nothing in this agreement prevents you going to the police, regulatory bodies, or making a public interest disclosure. Now, I've had lawyers say to me in the last week, well, what if your client, the company, doesn't want you to mention that? Is that a perversion of the course of justice because we are keeping that provision out of the agreement, that exception out of the agreement? The SRA need to give us better guidance. The CPS need to give us better guidance on what is perverting the course of justice, because another debate is, can you pervert the course of justice or attempt to if an investigation has not begun? So where a compromise agreement, NDA, settlement agreement stops you or tries to stop you going to the police, is that perverting the course of justice if no investigation has yet begun? But from my perspective, my client's perspective, I want it made bold in all settlement agreements. This does not prevent you. Any of the provisions in this agreement does not prevent you going to the police, and I think that has to be done.
You're just saying that the SRA need to make it more clear, and I can understand why you might say that, but surely lawyers, professional people, have an ethical code. Why is it that ethical code is so unclear to you as a profession, not you individually, but to you as a profession?
Because different people have different ethics. And I'm afraid to say I've seen in 25 years respondent lawyers behave disgracefully towards claimants and claimant lawyers. And it isn't just... Well, let me finish. I'm not saying all of them by any means, and I'm not saying the majority, but I've seen coercion, I've seen pressure placed on people that shouldn't happen. There is, and we're not just talking about compromise agreements, settlement agreements within the context of a lawyer's office. Some of the worst examples are where the lawyers or the barristers approach the claimant midway through a hearing, and this happens quite a lot. Withdraw now, we'll pursue you for costs. And the judge is saying, well, we need to get going again in half an hour. And then there's a complete waiver of your rights.
Do you think in the 90s there was a more macho, I won't use what I'm thinking term, culture within the legal, what do you call the big cheese companies, the magic circle? Do you think that they were a bit X-swinging about their approach to these things?
I wouldn't necessarily say that. There were boutique law firms 20 years ago who were balanced in their approach to both claimants and respondents. So I wouldn't necessarily say so. I think the problem with ethics, getting back to your original question, is it's a subjective thing. And if the SRA are going to help the profession, and I think they need it, there needs to be greater clarity.
Can I just say, in response to that, it's a nuanced thing though, because the issue we have as solicitors is our obligation is to act in the best interests of clients, and it would subject to our professional obligations. But if your professional obligations are not clear, your obligation is to act in the best interest of your clients until such point as you're breaching your professional obligations. Okay. So, in fact, you would be breaching another professional obligation if you were not doing that. So, where you get these difficult issues, you're right, Suzanne's right, you need very clear guidance as to what the position should be. Of course, different people will take different views, and I dare say I'd like to think I would have taken the view that in that case they've gone too far. But it's very easy to be very judgmental about it. Actually, in the context, your job is to act for the client, and clients often ask you to do things that you're uncomfortable with, and if you're acting for an employer or an employee, you can sometimes end up defending behaviour that you personally find abhorrent. But that's not your job.
Yeah. Time here. Yes, go.
I just wanted to also get Max to answer that question around the broader question about whether you feel that NDAs stop the law, and you have covered actually some of my other questions that I was going to ask, but I just wanted to give you the opportunity to...
I think I probably agree with what's been said. Firstly, you cannot require people to contract out of rights that have yet to be kind of crystallised. So, for example, we go back to what has been alleged happened at the President's Club. People were presented with an agreement before they started their work assignment which purported to remove their rights to make complaints of sex discrimination, whether harassment or otherwise. Now that's void. That's always been void. We have provisions in the Equality Act that specifically void that type of an agreement. Where you can have an agreement that will act to compromise your rights, it is possible for parties, and often both sides will want confidentiality with that. And in principle, I don't think there's anything wrong with confidentiality. As I think Gareth said, you'll often find claimants are as keen to have confidentiality in those agreements as respondents.
Confidentiality is a different thing to not being able to disclose something.
I would agree, and I'm not at all happy with this kind of creep that we've of the idea of NDAs. NDAs were kind of really commercial law terminology where two parties at arm's length want to enter into a confidential discussion about merging the business or whatever. I don't see that something as broad as that is appropriate in a kind of employer-employee relationship.
Okay, and so Suzanne has explicitly said that you want it red inked across the thing. This cannot stop you going to these authorities. Would you both agree with that?
I think broadly, yeah. I mean, if I just, speaking from my own experience of advising both employers and employees, where this will crop up, an employee comes in with a settlement agreement. We'll go through those provisions with the employee. Now, at one point, you will generally reach provision with regard to confidentiality. Now, when I was listening to the other speakers just now, I was trying to think when the last time I saw something that didn't include provisions which said this agreement is confidential to the parties, save in the case of the claimant, and then there's usually a list of people that you can go to. So, for example, being
your
practical.
Husband, your family, presumably, you're allowed to tell. Your husband. There's no way I'm going to sign something that then says I'm not going to tell my husband what happened.
Your spouse or civil partner will be able to be told about the contents of the agreement. Then it goes on to provisions with regard to regulatory authorities, a court of competent jurisdiction, HMR, tax authorities and such like. Now, to find an agreement without those provisions would be rather unusual. And if you're acting for an employee and none of that kind of leeway is granted to the employee, then there'd be questions.
And Gareth, do you agree with this redlining across all documents? I mean, like a draft thing that goes through it.
Look, let me say that I generally agree with what Matt says, but you certainly do come across confidentiality provisions that do not make that saving. And I remember having a specific argument with the other side saying they ought to put it in, and they said, well, you'll tell them what the extent of the limitations on this provision are. I think it would be better if they had to put it. I don't see any harm in saying they have to put it in bold, and it's perfectly clear this doesn't stop them going to the police or regulatory authorities.
Okay. So the EHRC, which you have referred
Yes.
to, has recommended that the government should introduce a statutory code of practice on sexual harassment at work, setting out that the circumstances in which confidentiality clauses preventing disclosure of past acts of harassment will be void. Do you support this recommendation?
I've seen the EHRC's proposals, and subject to further scrutiny, I think there's a lot to commend them.
Okay. Susan, do you support that?
I support it. I'd suggest that the recommendations don't go far enough to actually deal with the practical realities, because one has to bear in mind that many claimants do not want to go to court. And one question that the committee might want to consider is, why is that? Is it the way in which judges handle it? Is it the speed at which cases are dealt with? Is it the cost? One could look across other jurisdictions like the family courts, the civil courts, and take from that better processes than we have in the employment tribunals. And the important thing is to... the family court, for example, has a dispute resolution hearing in advance of the trial where the judge sits with the parties for a day or two, and it's wholly without prejudice. And the judge expresses opinions on the merits, but it isn't binding. Very, very effective process. We should have them in employment tribunal. Speed everything up.
Yeah, I mean, I don't know how much time there is to talk about them, because there's a lot of proposals in that, and I think there's a lot of nuance to whether some of those proposals are sensible or not. The one that I feel supportive of them. The one I feel most against is that the public sector should have a ban on using confidentiality provisions. I think there's a lot of problems with the way in which employment tribunal proceedings are handled in the public sector, and
I agree.
you'll be aware that you have to get Treasury approval if you're a public sector body before you can settle a claim. And the upshot is that very, very few employment tribunal claims are settled. And the upshot of that is it's very unattractive for most rational claimants to want to bring a claim against a public sector body. So the irony is that actually the effect of it will be to reduce further the number of claims against public sector authorities where people want to raise issues of sexual harassment. And actually I feel quite strongly that the public sector should be in the same, treated the same way as the private sector in this regard.
Quick supplementary from Vicky and then we'll...
Yes.
I really understand what you're saying, that if I've got a grievance with my employer, I may not want to go to a whole court process, and therefore I may want to settle privately, and that there is some benefit to the individual of having that choice. It's more about getting the NDA agreement clear about what I've signed away in terms of confidentiality and not. I'm not saying that the concept of having that out-of-court process, as it were, is a bad thing to do. What we heard again and again from Ms Perkins was, earlier, was not knowing what the options were. So it is an option that you can see does have value for many individuals. Is that clear?
Yes, I agree with that. I mean, I also agree that it would be worth examining why the employment tribunal process is so unattractive. But I have to say, I think some of it is inherent in any litigation of any sort, because you're seeking to do justice to both parties. And it's probably an unpopular thing to say, but there are also people out there who are accused of harassment who've not harassed anyone. And those people are also entitled to, for example, the benefit of a non-disclosure agreement.
Yeah. Okay.
Tonya.
Okay, thank you. It's been suggested that the use of non-disclosure agreements may facilitate repeated sexual harassment by groups or serial perpetrators. High-profile examples where such an effect that has been alleged include the President's Club and the Harvey Weinstein cases. To what extent do you think NDAs are used repeatedly to settle complaints of sexual harassment against the same perpetrator?
I think the most common situation is rather like in Weinstein, where you've got someone who is all-powerful within an organisation who themselves is the perpetrator. And I'm afraid I have seen that situation arise in practice.
And the other problem is that usually, at least in the city generally, you have tombstone references. He worked between these dates, he did this job. So the next employee, even if he's released or dismissed or resigns, doesn't get to know that this person is a repeat offender. And perhaps we need to look at whether there should be an obligation to refer on to a new employer, in certain circumstances, the findings of harassment.
What might be something that an employer would already be obliged to tell another employer in a reference? Presumably a criminal offence?
Your only duty is to not mislead in the giving of references. And it's a very vague area. If you say nothing at all, if you give a tombstone reference and don't refer to him as a man of integrity, say nothing, are you misleading by not mentioning serious sexual harassment? And that's where law needs clarity.
Well, to be fair, there are changes to that because of the senior managers regime, and in financial services there are now rules saying that you have to comment on whether you have concerns about someone's fitness and propriety.
But that only is in financial services.
Financial services, insurance, but correct, it's limited to financial services and insurance at the moment. There probably are actually other regulated sectors, which I'm probably not qualified to comment on, but like teaching and such like, I think are also covered.
Interesting point.
Okay. What potential is there to use clauses in NDAs to limit the potential for covering up this repeat offending? For example, by requiring them to keep records in harassment cases, and I know you've alluded to this now, but to prevent future settlements in relation to the same harasser.